but it's still, there are very few international lenders and international aircraft lessors who would ignore a Singapore court order with extraterritorial effect, in our view. So from our perspective, we find it's it's very, very flexible, and in many ways, given the fact that you could get Chapter 15 recognition quite easily of a Singapore proceeding, then in many ways it does almost everything that you might want a Chapter 11 to do. A slightly higher threshold to propose a scheme of arrangement, which is 75% in value against the 2/3 threshold in the US courts, but that's maybe mitigated by some very interesting pieces of legislation which have not been tested yet, in my knowledge, about sort of creative cram downs where minority classes may not be able to frustrate and hold up a restructuring unreasonably. And I think there's going to be some very interesting test cases in the future on that.
Joel, can I just stop you? Joel, can I just stop you there? I just want to make a thing on your debtor-in-possession funding, just to make two observations. Coming from Hong Kong, I'll have to say something about the debtor-in-possession funding to rub up the Singaporean friends down there. It seems very prescriptive, your funding arrangements in rescue in Singapore, and certainly a lot more difficult to obtain the funding than, say, in the US. The other thing, more probably particular for our seminar today, is that airlines are particularly difficult sometimes to get DIP funding for, because of the lack of unencumbered assets. So we've seen in a couple of filings recently that the value has been extracted from the frequent flyer programs and the databases of those, and they've been the things that have been funded rather than assets of the airline, or other than hard assets, what could be considered hard assets.
I will agree that the Singapore regime is nascent in terms of its debtor-in-possession. I think there's been 4 applications so far, of which 3 have been granted. And the first was really perhaps a bit of a try-on, where they were trying to say an equity subscription could be a debtor-in-possession funding. It's, I mean, considering how new the law is, I'm pretty encouraged by the availability of debtor-in-possession funding. I'm also encouraged by the fact that courts will allow things like, as you mentioned, with, for example, pre-existing debts to be rolled up for essential suppliers. Again, of course, there's got to be parameters around that. Fairness to other creditors. If you are giving a rolling up super senior status to certain creditors over other creditors, there's got to be some fairly good grounds. And I don't think the courts have, necessarily have not had the case flow to sort of determine all of those issues yet. But what I've seen is that the courts are very willing to engage with and consider those issues. So I would not be the naysayer saying it's not possible. I'd simply be the person saying it hasn't been tried yet. If there's a compelling case, get in front of a Singapore judge and make the case in the best way you can. And I found them to be very receptive to good cases.
Yeah, it's just a huge industry in the US, as you know, and it's regarded as pretty much non-risk lending.
Yeah,